Well, welcome to all of our potential listeners here. I am Lee Solomon, Junior Associate at BakerHostetler, here joined by Ron Gaither and Libby McCurrach, two excellent attorneys who work out of our Atlanta and New York offices as the co-chairs of BakerHostetler's Sports Industry Group. We'll dive into our topic here shortly, but first I want to open up the opportunity for Ron and Libby to explain a little bit about their practice and tell us a little bit more about Baker's sports industry group at large. So Ron, Libby, please let us know what do you guys do and what does the firm do for its clients?
Sure. I'll start. I am Ron Gaither, and I have been practicing with Baker nearly 10 years now, and I have been in the sports space nearly probably 20 years of my practice. And currently, my practice consists of representing clubs, professional sports teams at Major League Baseball, the NFL, the NBA, and I also do some league work for Major League Baseball and some other leagues as well. I also represent companies that manage or have large sports portfolios and sponsorship and license agreements. And so I do that work as well. And so I always tell people if it happens anywhere inside of a stadium or an arena, I handle it. So.
Hi, great to be here today. And my practice intersects with Ron a lot. Ron and I work together all the time with the leagues and the clubs. And my practice has some other variations with gambling work and NIL practice as well. And those issues sort of dovetailed together and came to the forefront at the same time. But also as that intersects with advertising and marketing and sponsorship, which is where some of our sort of non-league team clients come in. And that's when a lot of our work comes from.
Very nice. Well, again, we appreciate you guys taking the time to chat today. And as you guys both know, we are here to discuss the status of the NCAA's potential landmark settlement of its antitrust litigation in the case House versus NCAA. Now, for those of you who are listening who don't necessarily know, this litigation concerns three consolidated class action lawsuits brought by former student athletes who claimed that the NCAA's pre-NIL ban on student athlete compensation was unlawful and violated antitrust regulations. So since this case is rapidly approaching settlement, we figured we ask Ron and Libby to walk us through some of the terms of the settlement and specifically, what the future of college athletics might look like if the settlement terms are approved. So to dive into the topic a bit, I first want to ask you both, how did we get here? This is a popular case that has, a lot of people who are interested and have been tracking it closely. But for those listeners who may be unaware of what we're talking about today, could both of you give us a little bit of background on how this lawsuit against the NCAA got started and how it's developed over the last year and a half?
You want me to start or should you? I realized we didn't realize who would work it out, but I'll start. So this specific case originates to 2020, but the NCAA has basically been in litigation since the time we were born over some of these issues. But really this case came to the forefront after the O'Bannon case, which went all the way up to the Supreme Court in 2021. Where the Supreme Court found that the NCAA was guilty of a lot of antitrust violations. And that was a real sea change in terms of allowing athletes to be compensated for their name, image, and likeness. But those payments were coming from outside. So that was sort of opening the floodgates of vendors outside of universities. And so what's different with House is that you have a class of athletes who are saying we actually deserve a piece of the revenue generated through ticket sales and media rights. And we should be a part of this too. And so House is revolutionary in that it's saying that the athletes who are at the end of the day part of the product, that they should take part in it as well, which the NCAA has always said, that's separate and that's, belongs to the university and to the NCAA. And so this is sea change.
Yeah, and to Libby's point, the NCAA has been sued or has been in active litigation for at least the last 15 or so years. And it started with O'Bannon, then Alston, now House, Hubbard, and I forget the third case that was all consolidated. And, to Libby's point, the NCAA made a determination that in order to go forward, they needed to find some kind of way to resolve these cases because these antitrust cases were never going to go away. And so there was this tiny little, not tiny, but they're piecemeal approaches to what now is this revolutionary change inside of collegiate sports. And I think it's huge. And if anyone that is a fan of college sports will appreciate that over the next year or so, college sports has changed dramatically.
Yeah, and that's a good way to put it. I know it's funny as a Columbus, Ohio citizen to see the monster NIL deals that are going on when at one point in time, athletes were coming under scrutiny for selling their memorabilia for tattoos and things of that nature. So it's certainly changed a lot. Obviously, the NCAA is having to grapple with that change. I'm now curious for you guys who have followed this settlement so closely. What are some of the proposed settlement terms that are out there? And as we approach the potential for settlement, how do you see those settlement terms potentially playing out for student athletes and for colleges and universities?
Yeah, and so I'll start this one. And so I guess one of the first things to talk about as it relates to the settlement is back damages or back wages or back damages as it relates to um, student athletes who could not capitalize on a name, image, and likeness. And there's $2.8 billion that will be paid out over, I believe, a 10-year period to these student athletes. So, I mean, that is just, I think it's one of the largest antitrust settlement cases. And so that is an extraordinary amount of money paid to these student athletes for these past damages.
And then it's also forward looking too. So you have the piece of people who I believe were athletes from 2016 to 2021, who, so before they were able to be compensated via the O'Bannon decision, who weren't able to capitalize at all on their name, image, likeness. And so they're the class. So, but forward looking now, schools are going to be able to give, and it's going to be up to $20 million, where they're going to divide amongst their athletes as they revenue share from the various media rights deals and other things that how the sports generate revenue.
Got it. Yeah, no, I am also curious as it pertains to dealing with the teams themselves and how they've dealt with scholarships in the past and roster limits going forward. Are there any differences in the way that they're going to be treating, how the money will be distributed, whether it's, three separate buckets for scholarships and NIL and school payments, or if it's all merged together? There's so many questions that are surrounding here. I'm curious, are you guys aware of how it's going to be played out in the future?
Yeah, I think to answer your question, it will be played out in the sense that the $20 million, $20.5 million salary cap is just that is what the schools can actually pay the student athletes. And you all the schools have agreed upon this number, this $20.5 million. And so that sets the limits for what can be paid. However, now the student athletes still have an opportunity to capitalize off their own name, image, and likeness from outside third parties as well. And so that won't, count against the pot. However, I suspect, that's part of the things that we'll may talk about later, this idea of how do schools, how does the NCAA, student athletes, how do you go about monitoring the money that's paid to student athletes outside of that cap money?
Right. No, it's a great point. And obviously something that we'll have to continue to monitor as these terms continue to come to light. So just to get back to the timeline that we're currently on, I'm curious, at what stage are we with the approval of this potential settlement? Has the judge given us any additional insight into what she thinks will push the settlement across the line at this stage? And further, I think the initial timeline was set for somewhere starting in the academic year of 2025, 2026. Does it look like they're still following that timeline at this point?
The answer to that is no. The original approval deadline has come and gone. That was, I believe, April 7th.
Hmm.
However, Judge Wilkins was very, very clear in her reasoning for postponing or delaying the final approval of it. She had concerns about provisions under the settlement, in particular, the roster limitations. And so once upon a time, there were scholarship limitations, meaning schools could only give so much money to their scholar athletes or scholarships to their athletes. Now, under the new program or the new settlement, now you can have unlimited scholarships. However, there's a limitation on the number of roster spots you have on a particular team. And you can see, the thinking behind that. The thinking behind that is if you have unlimited scholarships and you have unlimited rosters, now you could literally stack talent on your teams. And so the parties, in particular NCAA, said, hey, we got to have some roster limits because, look, we're still trying to maintain a competitive balance as it relates to college sports, and we believe roster limitations can do that, in particular, given the fact that now there are no scholarship limitations. So Judge Wilkins was concerned about the roster limitations because in essence, as schools begin to prepare for this kind of new world order as it relates to college sports, now they're starting to start cutting student athletes, trimming down the roster. And there are student athletes who are literally in the class who would be negatively impacted by this particular settlement, meaning, hey, yeah, sure, there are unlimited scholarships, but you're one of these student athletes who we're going to have to cut under the roster limitations. And Judge Wilkins didn't like that. And, candidly, from a, personal standpoint, I don't like it either. So.
Yeah, so it's really on the parties now to figure out sort of a workaround on this point and come to a better resolution so that it doesn't harm the class. Again, right now, I think the thing that was most recently put forth was something that wouldn't harm, the people who are part of the class would be grandfathered in, and it wouldn't affect the current roster limits, and would only go that portion of this wouldn't go into effect for a few more years until everyone in the class was formally out of universities. But it's still an open question where, again, that is a harm against athletes and against rosters. So, and people will be denied that opportunity. So I guess if everyone's denied the opportunity, it's equitable, but it is a question about that change moving forward because less people will have the opportunity.
Right. No, all great points. And we've seen the NCAA previously deal with COVID and adding eligibility to players who are on their rosters while, seemingly harming some of the high school talent who's looking to push into the college ranks as well. So, it's give and take with everything, but definitely will be something we'll have to monitor to see if they can push this settlement through. My next question for both of you would be, if the settlement is ultimately approved, what are some of the legal considerations that schools, athletic departments, any interested party should be aware of as we potentially go forward with a new dynamic in college sports?
I mean, assuming it gets approved, and obviously everything looks like it will, it's going to be a massive sea change, especially for university compliance departments. And I think there's a huge issue about what everyone's going to do with the collectives, because I think the idea now is, since you will be paying athletes directly from the university, I think that some universities that don't have collectives are going to start them because you could bring them in-house. And it's not as complicated as an outside third party, though obviously a lot of collectives work very closely with the university. So it's a question of what these sort of outside entities, where they go from here, which I think they'll still exist, but I think there now is, there's a tension now in terms of if you donate to the university, that's tax deductible, whereas if you donate to a collective, it's not. So I don't think any collectives have that much trouble fundraising, but especially for bigger schools, but because obviously donors love to get great talent. But I do think that that will be a new tension, and just, I think, I mean, I've seen a lot of talk about how collectives aren't going anywhere, but obviously they're an invention of the last, 3 to 4 years. They're very new inventions. So in terms of how that pivot happens, there will be change there.
Yeah, I think Libby's hit the nail on the head as it relates to the role of collectives and how we actually view collectives under this new house paradigm and that new house dynamic. Because now, you know, schools are literally directly paying student athletes. So the question then is, if that's the case, what's the role of the collective, which is a group of boosters who go out, they generate funds in order to help pay student athletes? And so the question then becomes, are these going to be considered third-party payments to student athletes that don't count against the cap? And so that's a fantastic question, because we would all have a problem with the professional model, whether it's Major League Baseball or whether it's the NFL, if you take any star player, let's use Pat Mahomes, and he makes X number of dollars a year under the cap. However, he has another outside deal that pays him money for the things, for his performance, and that would just be volatile of CBA and everything that's negotiated. So the question then is, under this new model, will the collectives be highly scrutinized for the arrangements and deals that they seek for student athletes to make sure that they are commercially appropriate agreements, and make sure they're not paid for performance, but also whether or not the money goes against the 20.5 cap that's in place this first year.
Right. Yeah, and as Libby said, these collectives are a new development that have come with NIL, and now with the NCAA lessening some of the strict burdens that they put on the schools and staying out of it. Because they'll be so intertwined, it'll be interesting to see how that money gets reported, how the deals come about, and ultimately how that cap falls into place. Well, finally, we'll close out here soon, but I want to offer this up to you guys as an opportunity to give any final thoughts you have on where college sports is heading, where the House settlement might also ultimately be heading, and just any words of advice really for anyone who might be interested in the potential settlement of this lawsuit and change to the NCAA's dynamic going forward.
Sure. Again, I think that, as Ron put it correctly, where this is a paradigm shift, this is bringing, behaviors that have been going on, it's sort of a formalization of things. Everyone knew people were getting paid under the table, and now it's sort of the same thing that we've seen in gambling in a lot of other places, where now it is sort of, shining a light and letting it be, letting a free market exist. And I think this is an interesting sort of inflection point of them trying to, it's both putting it, formalizing it, but also a little bit of trying to put it back in the box too, where I do think they are trying to put some guardrails on this, because it has been a Wild West situation where there's no uniformity, there's no universal contract, there's very little visibility into what people are getting paid, apart from it goes to the college compliance department. But again, this will, in terms of how they're trying to do this, and again, I believe they're going to work with Deloitte. I think Deloitte's the front runner, is going to be sort of a repository for contracts. What they're going to do with valuation of these contracts and trying to figure out what is fair market value. I mean, there's so much happening. As I said, I don't even know what to tell someone to look for, other than just to stay tuned. We're going to have another conversation about this in a year, that obviously a lot will have been cleared up, but a lot of things probably can't even predict.
Yeah, again, Libby's hit the nail on the head, and I think I'll say in closing, what we're seeing right now is the professionalization of collegiate sports. Candidly, collegiate sports have been professional since the last 20, 30 years. I mean, they're just huge business. I mean, the TV rights deals for March Madness are absolutely extraordinary. You see coaches inside of conferences being paid upwards of 10 or $11 million per year. The professionalization has always kind of been there, but now it's just an open, let's create a structure for what we know already exists. And there are going to be some bumps. There are going to be some challenges here and there with anything involving, billions of dollars. There's going to be programs that, push the boundaries and challenge the rules. There's an old adage, if you ain't cheating, you ain't trying. And so there are going to be issues related just to to this point of contracts and what's the true reasoning, the true value of these contracts to these student athletes. And so I think that the universities and athletic departments in particular are going to have to just grow their athletic departments, their compliance departments, or that's going to be something that's going to have to be farmed out to outside counsel to help them manage these the volume of contracts and agreements that they have with student athletes and outside vendors. And so I'm looking forward to it. I'm a huge sports fan, huge college fan, and so I think it's a great time to be a sports lawyer and, help kind of create and, talk about, college sports over the next, 5 or so years.
Completely agreed, Ron. It's a great time to be in sports. And as final thoughts, I'd just like to say thank you to the both of you for taking this time to have this conversation. As always learn so much from being able to, chat with you guys about this topic. I want to thank the listeners for tuning in today. And I also just want to remind anyone who's listening that if you're looking to stay up to date on all matters related to NIL or sports industry practice in general, we ask that you follow BakerHostetler Sports Industry Group on LinkedIn. We'll also leave Ron and Libby and myself the emails for all of us in the description of this video. You have any inquiries, please feel free to reach out to us. And again, we just want to thank you for listening. So you all have a great day. Thanks.